You're charged with assault on a security officer. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. 2024 CR 012237, State versus Daniel Munoz. Could I have parties announce?
Enter State.
Megan Enriquez for Daniel Perez Munoz.
And are you Mr. Munoz?
Yes.
So do you want to use the interpreter?
Yes.
Yes, I want to use.
All right, so yes is not Spanish. I know a little Spanish, and I know yes is not the word in Spanish. Am I right? Okay. All right, we have an interpreter here. If you can raise your right hand, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Catalina Delgado, Delgado, license number 2222.
All right, defense, all of the documents are in English. Were these documents explained to your client in Spanish?
Yes, Your Honor.
Mr. Munoz, all of these documents are in English. Were they explained to you in Spanish?
Yes,
And counsel, do you speak Spanish fluently?
I do, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the application for deferred adjudication with your attorney? Did you understand it?
Sí.
And did you sign it?
Sí.
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
Did you understand you're charged with assault on a security officer? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Sí.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand that and intend to give up your rights and enter into a plea in this case?
Sí.
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Sí.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, but I would state for the record that I did have him evaluated for both competency and also for sanity at the time of the offense. He was evaluated by Dr. John Delatorre, and the doctor concluded in both instances that he was competent to stand trial and that he was not insane at the time of the offense. I have read the doctor's reports, reviewed them with my client, and ultimately did agree after the evaluations that he is competent to stand trial and was legally sane at the time of the offense.
All right. Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Has anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí, claro.
Yes.
Are you a U.S. citizen?
No. I would like to speak to that as well
Yes.
and put some things onto the record. I did consult with an immigration attorney from the Managed Assigned Counsel office. He did interview my client. He did write a padilla letter. My client is a legal permanent resident. He has a United States citizen wife, United States citizen children, a United States citizen father, although he was not born here in the United States. I'm going to read I'd like to read some of the padilla letter into the record, and I've advised my client that the immigration attorney said that he was actually already deportable prior to this offense. He says that he may be eligible for the defense of a cancellation of removal. Also that the conviction of the currently charged offense should not make him lose eligibility for cancellation if he is eligible, because it is not an aggravated felony. So based on that advice regarding possible immigration consequences, he on his own has decided that he does want to move forward with this plea for deferred adjudication. But I've also advised him that immigration laws are fluid and changing, and that really any type of criminal offense could result in his deportation, exclusion from entry into the country, and denial of naturalization or denial of renewal of his residency. But I also gave him the advice that's stated in the video letter that's specific to his situation.
All right. So have you had ample opportunity to discuss your immigration status with an immigration attorney? Yes. All right. And do you understand the consequences of entering into a plea agreement in this case and the impact that will have on your immigration status?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sí.
According to the plea punishment, the state is recommending deferred adjudication. Did you understand that to be the plea?
Sí.
Yes.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí.
Yes.
Excuse me. Counsel, have there been any such motions?
God bless you.
Thank
No,
you.
Your Honor.
And outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be no contact with the Haven for Hope or with the complainant, and an application for felony drug court. What I can tell parties is that I received an email from felony drug court and they are now at capacity. So I will have him interviewed for felony drug court, but he may be on a waiting list or may they not accept him because of capacity issues.
And Your Honor, the reason that I recommend an application for felony drug court is that he may not be able to get in for reasons that are beyond his control.
Okay.
Will he still be released, or does he have to wait in custody for that process?
Well, I'll do the felony drug court evaluation. They'll do it in custody. Since today is Thursday, they'll have it done by next week.
Okay.
Okay. All right. Did you understand?
I just want to tell him really quickly. Did you understand that you'll have to wait in custody while the evaluation is done to see if you're accepted into the program?
Yes.
And she's saying she believes that the program is at capacity, so if that's the case, then that will not be part of your probation.
The recommendations from the state, and the court does not have to follow those recommendations. Then to the
Yes.
office is charged. How do you plead? Guilty, not guilty, or no contest?
Me pongo.
No contest.
State any evidence?
It offers to the
No objection.
All right, state, you may be excused. Did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sí.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Sí.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I mean, he's been very respectful to me throughout this whole entire process. He's been patient with the process, with the various evaluations that we had to have done to do a thorough defense of his case. His family has been very patient. They're here in the courtroom, and I do think that he does have a good support system to be successful on this probation. They've been patiently waiting for him to come home, and thankfully we're almost there, it sounds like. And I think that hopefully the court can provide him with the tools to be sober, to be on his psychiatric medications and move past this.
All right. All right, have you ever been employed?
Sí.
Yes.
Doing what?
Construí muchas casas para los bebés.
I built
Bueno.
several houses,
All right, and do you have any children?
Sí, 4.
4 girls.
And do you see them?
Sí.
Yes.
All right, this is what the court is going to do. Well, let me ask you this. If he's released, is he going to be living with his parents or somewhere else?
Would you live with your parents or with your wife?
With my wife, I think.
All right. Court is going to sentence you to 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. There's to be no illegal reentry into the United States, TAP evaluation out of custody, felony drug court evaluation in custody, MIC evaluation out of custody, follow all recommendations of the TAP evaluation, field visits 1 time per month for 6 months, proof of employment within 30 days of release, no employment as a home health care provider or with minors, 200 hours of community service restitution. Once parenting classes are completed, the court will deem those hours satisfied. There's to be no contact with the complainant. Or Haven for Hope. And with regards to the community service hours, 200 hours of community service restitution, there'll be 100 hours deducted for parenting and another 100 hours deducted for an anger management class.
Okay.
All right. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right,
Yes.
good luck to you. Calling 2025 CR 013339, State versus DeAmber Cross. Can I have parties announce?
Alma Benavides from Ms. Kraus.
And are you Ms. Cross? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Are there any applications in this case?
No, Your Honor.
Ms. Cross, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Kraus, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? All right, off the record for a moment. State, on this case,
I don't know how she'd be a state jail repeater with this one teams who tricked that.
oh yeah, so I don't know why they put that in there, but okay. Thank you. No, it's whoever indicted
Yeah.
this. Don't take that. All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Ms. Cross, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? You need to speak up.
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the Bear County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motions, Your Honor.
Then to the offenses file, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The offer state one in the caption.
We reviewed them, Judge. We have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're just asking the court to follow the plea bargain.
All right.
Currently has 26 days credit.
All right, the court will follow your agreement. The court will sentence you to 6 months in the state jail facility. There's an $800 fine. Time and money will run concurrent. There's to be no unsupervised contact with minors, and the court will give you credit for any time served. And I'll suggest that just 1 second, 6 months in the Bear County Jail, under 1244.
Thank you, Judge.
And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Yes,
Your Honor, did you impose a fine?
yes.
We would ask for time and money to run concurrent.
Oh, I did.
Okay, thank you.
No
Judge.
problem.
Thank you, Judge.
You're welcome.
Thank you.
All right. Because it's a plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal, because this is a felony conviction, not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you do not stop using drugs, you know what's going to end up happening? Either you're going to be in somebody's jail, somebody's prison, or somebody's going to have to identify your body. There are many places in Bear County
where you can get help. So if you don't know who to call or where to go, you come back here. Before January 1st, I will still be here and I'll pick up the phone to try to help you, okay?
Yes, ma'am.
All right, good luck.
Thank you.
Two
Daniel
different
Munoz.
people, two different crimes. But inside the courtroom, both lives were about to change forever. First, Daniel Munoz stood before the judge, a father of 4 daughters, a husband, a man who built houses with his own hands. But in that moment, none of that mattered. To the court, he was just another defendant charged with assault on a security officer. The judge reminded him of the reality. This was a third-degree felony, punishable by up to 10 years in prison and a $10,000 fine. But prison wasn't the only thing Daniel had to fear. He wasn't a U.S. citizen. His lawyer revealed something that changed the entire atmosphere in the courtroom. Daniel was already at risk of deportation. One mistake could erase the life he had built in America with his wife and 4 daughters. The judge carefully made sure he understood every word, every consequence, every right he was giving up. Instead of immediate prison, the court gave him a difficult path forward: 4 years of strict probation, random drug tests, anger management classes, parenting classes, community service, and one warning: if he breaks the rules, he could face years behind bars. Daniel lowered his head as the decision was announced, knowing his future now depended on proving he deserved a second chance. But the courtroom wasn't done yet. Next came Amber Cross. She was charged with possession of a controlled substance, a state jail felony. The judge explained the punishment clearly: up to 2 years in jail and a heavy fine. Amber accepted a plea deal. The court sentenced her to 6 months in county jail and an $800 fine. But before ending the hearing, the judge looked directly at her and gave a warning that echoed through the courtroom. If you don't stop using drugs, one day you'll either be in jail, in prison, or someone will be identifying your body. Then the judge did something unexpected. She offered help. She told Amber that if she needed support to change her life, she could come back and ask for help. 2 defendants, 2 different stories, but one powerful message from the courtroom: one mistake can change your life forever. But sometimes, the court still leaves the door open for a second chance.